You're welcome. It's so great to see you on this beautiful evening here at this very special place, which is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. Beautiful. You get total full marks. That was so glorious. Thank you so much for reciting the motto, and thank you all so much for being here to discuss a crucially important topic: the new justice and the future of the Supreme Court. This is the first week that Justice Neil Gorsuch has sat on the court. I had the incredible thrill yesterday of being in the courtroom and seeing the new justice in a very interesting case about religious liberty that I'll tell you about in a second. And we just have a dream team of commentators to discuss the new justice, and I will introduce them in a moment. I want to put in a few plugs. First, for Member Appreciation Day, next Saturday, April 29th. Who here is a member of the National Constitution Center? Wonderful. Well, we're going to say thank you and express our appreciation to you next Saturday with a really great series of programs. If for some reason you haven't seen the newly renovated Freedom Rising show, come and see it. It's just spectacular with this beautiful renovation of the Sidney Kimmel Theater and new technology, and very exciting. Special tours of the Prohibition exhibit, wonderful tours of Signers Hall. Also, Living News. This is a question. Who has seen Living News or knows what it is? Very few people. So it's this beautiful show, a live theater show, where 3 actors act out live constitutional questions, mostly for school groups. And they present both sides of the issue. Can the police search a backpack? Is it constitutional to ban free expression in schools? And it's incredibly moving, and there's talk back afterward. And just seeing these actors present both sides, I find among the most meaningful things we do. So whether on Member Appreciation Day or some other time, it's in the core, and go, please, and be inspired by Living News. And then just a superb series of programs for the rest of the spring. May 1st, The Future of Fake News with Susan Glasser of Politico, Glenn Kessler of The Washington Post, and Brian Stetler of CNN. What an interesting program that will be. May 8th, I'm going to interview the great First Amendment advocate Floyd Abrams about free speech. We'll have Senator Mike Lee, the National Constitution Center's visiting congressional scholar, and also co-chair of our new Madisonian Commission, A Constitution for All, which we launched so excitingly last Thursday on Freedom Day, is going to come to discuss his new book. And David Horowitz, one of the country's foremost conservative commentators, will discuss his new book, Written Out of History. It's just going to be a constitutional feast here at the center. And now it's my great pleasure to introduce 3 of America's leading constitutional commentators, great friends of the center. You've heard them on the We the People podcast. You've seen them on the stage. And now, united for a victory tour to discuss the future of the Supreme Court, we have Joan Biskupic, a great Supreme Court journalist, one of America's most thoughtful and learned commentators on the court. I've known her for almost 2 decades. She's been writing, we've both been writing about the court for nearly that long. She's written superb books that I want you to read, if you haven't yet, about Justice O'Connor, a great biography of Justice Scalia, and now she's working on one of the first, and I'm sure definitive biographies of Chief Justice John Roberts. Brianne Gorod is Chief Counsel for the Constitutional Accountability Center, our great partners. They are the group that file briefs arguing that constitutional text and history, honestly interpreted, can lead to liberal as well as conservative results. And before serving in her current role, she was counsel at O'Melveny & Myers and a law clerk for Justice Breyer. And Ilya Shapiro is Senior Fellow in Constitutional Studies at the Cato Institute, Editor-in-Chief of the Cato Supreme Court Review, co-chair of member of the Constitution Center's Coalition of Freedom Advisory Board, and author of the most entertaining briefs filed before the Supreme Court. He files an annual funny brief. We do podcasts on them. They're not always safe for work, but they are genuinely funny, and you should check out his incredibly funny briefs. Ladies and gentlemen, please join me in welcoming Joan Biskupic, Brianne Gorod, and Ilya Shapiro.
Thank you.
Thank you so much. So glad you're here.
Right next to you. Right
in the middle. So very wonderful. All right. Welcome. Wonderful. So as I said, Dear friends, I was in the courtroom yesterday and I saw Justice Gorsuch ask one of his first questions in the Trinity Lutheran case. It was just dramatic to see the whole bench look different because, you know, the justices sit by seniority and he's now on the rightmost side and Justice Kagan is on the leftmost side because they're the most junior justices, and now Justice Thomas and Kennedy are flanking the chief. But Justice Gorsuch's question, which signaled skepticism that Missouri could constitutionally deny funding to religious schools, that it made...
It was Gorsuch a good question.
Nice, nice. That was a very good beginning to what I'm sure will be a series of excellent interjections in the Shapiro spirit. But, okay, you can take it, Ilya. So everyone thought it was going to be a 5-4 case and Gorsuch was going to be the deciding vote, but it seemed more 7-2 with Breyer and Kagan both favoring the neutrality position and strict separationism only embraced by Justices Sotomayor and Ginsburg. So Ilya, was the effect of Justice Gorsuch on religious liberty cases overstated?
Well, this was a surprise. I was there as well, and it had been held, this case, for over a year after cert was granted, and the conventional wisdom was that the court hadn't scheduled it because they were expecting it to split 4-4. They needed a ninth justice, but my reading of it is the same as yours, same as the most commentators, and so you know, I'm sure Justice Gorsuch will be solicitous of religious liberty as he has been in the past, but his will not be the deciding vote in this case.
But Brianne, on religious liberty, there are a series of very hot-button issues relating to the Hobby Lobby line of cases where the court held that religiously observant corporations don't have to provide contraceptive coverage. Some are coming down the line, including whether a religious wedding photographer can refuse to take photos of or bake a cake for a gay wedding because he objects to doing that. Might Justice Gorsuch cast deciding votes in those kind of cases?
I think it'll be really interesting to see what happens with that case in particular. This is one where the court has considered it several times now, so that's led to a lot of speculation about whether, you know, perhaps there aren't the votes to take it and someone is upset about that and writing a dissent, or possibly there are 3 justices who want to take it who just needed that 4th vote, because it takes only 4 votes at the court to hear a case, even though, of course, it takes 5 under normal circumstances when there are 9 justices to win a case. So, you know, the court will be considering it again, this time with Justice Gorsuch casting a vote, and it'll be interesting to see whether this is one that the court now takes.
Great. Joan, you can comment on religious liberty if you like, but I want to now pull back and say you wrote a really interesting and illuminating piece comparing Justice Gorsuch to Chief Justice Roberts, about whom you're writing a biography. And the similarities you teased out were so interesting. Tell us about those similarities and tell us how the similarities between Gorsuch and Roberts might fundamentally affect the dynamics on the Roberts court.
Sure. Thanks for having us. I remember the night that the Gorsuch nomination was rolled out. We were together then, too.
We were in a very fancy place
yes.
on CNN, which was very
Talking
glamorous.
about it.
And we watched it in real time come down.
Yes, it was wonderful
so cool.
to see President Trump come out and say, "Are you surprised?" I mean, it was like some sort of beauty pageant. A rollout. But
yes.
Neil Gorsuch actually has remained more of a dignified presence through this, and that's one of the comparisons I was making with Chief Justice John Roberts. Both prep school boys. Neil Gorsuch went to Georgetown Prep in Washington, D.C. The chief went to La Lumiere boarding school in northern Indiana, where he grew up. They both went to Harvard. They both have wonderful resumes, and also have a certain way of presenting themselves as very less than divisive as Justice Scalia liked to mix it up. I think we're going to see Justice Scalia's successor not have that kind of personality of kind of more polarizing as we saw. But the question I raised in the piece that you're nicely referring to is, will our new justice be more in the mold of Chief Justice Roberts in terms of maybe tipping over a little bit to the left on key cases, wanting to work for consensus? Or will he be more like Samuel Alito and Clarence Thomas, our 2 most conservative members now, who are pretty unyielding on their ideology? Right now, if the court is, well, before we had all 9, if we had a 6-2 vote, it generally was over by themselves, Justices Scalia and Justice Thomas and Alito. And Neil Gorsuch's record looks pretty conservative, but will he be more of the type like Justice the Chief and want to bridge that gap? And the one thing I would say about the religious liberty case is that I wouldn't count out yet some polarization on that. I think they don't want to look polarized. They don't want to go back so quickly to that 5-4 divide. The Chief especially really does not want to make this court look like such a divided along political and ideological lines court. So we'll have to see when the ruling actually comes.
We will indeed, and Joan raises a crucial question that I now want our other colleagues to answer. Ilya, what's your answer to Joan's question? Will Justice Gorsuch, who presents very well and seems collegial, share Chief Justice Roberts' commitment to institutional legitimacy in a way that might lead him toward the center in some cases? Or will he be the libertarian justice you praised so enthusiastically and pull the court to the right and make it more polarized?
Well, I don't think it'll make the court more polarized just because of his collegial demeanor and manner. And the one kind of other aspect of the dynamic that Joan didn't mention was perhaps he could vote like Scalia in many ways, but attract more flies with honey than with Scalia's vinegar. And so result in a less divisive court, even if he himself is more towards Alito and Thomas on many things. I mean, look, I think there's a lot in his record that wherever someone is on the center right or even the center left, like Neil Katyal, President Obama's former acting Solicitor General, would like. His commitment to structure and originalism and textualism, his scholarly erudition, sharing all of those with Scalia, but being less off-putting, less acerbic, and so I think both on the way that the commitment to the idea that the structure of the Constitution protects liberty, federalism, separation of powers, fighting back on over-deference of the judiciary to the administrative state, to the executive branch. On all of these things, he'll be, I think, better, in fact, than Scalia, but on a different dimension than Thomas and Alito, perhaps more solicitous of criminal defendants, for example, that Alito, as a former prosecutor, does not tend to be, or things like this. There's some of his more famous cases that got talked about at his confirmation hearings were actually on criminal immigration law, which is obviously very topical in today's political discourse. And so a lot of his examples of his pushback on government power, on the executive, were in these areas. And so you might have a kind of a heterodox result in the Trumpian age.
Thanks for that. So Brianne, Ilya sketches out a libertarian dream and something of a progressive nightmare, that Justice Gorsuch would be so effective that using
Jeff,
honey...
Is it really that progressives want to give Scott Pruitt and other executive agency administrators more power rather than review what they're doing?
That's an excellent question, and I do want to raise the question of whether Justice Gorsuch's wanting to question what's known as Chevron deference to administrative agencies might be good for progressives in the age of Trump. But on the question of Justice Gorsuch's effect, honey and vinegar, the fear is, first of all, that he'd bring Kennedy over to the libertarian or conservative side in cases where he previously had been inclined to side with Breyer and Kagan. Might that happen? Describe your conception of the dynamic between Kennedy and Gorsuch, and more generally, do you think he might bring anyone else over and make it a more conservative court?
Sure. So, I mean, first, I just want to say on this question of Gorsuch and Roberts and how they compare, I think that is a really interesting question because obviously the Chief Justice has really surprised some people over his first decade of the court because he has sometimes surprised parting ways with some of the fellow conservatives to, vote with the more progressive members of the court. And I think, the reason why, which has been alluded to, is that he cares very deeply about the role of the Chief Justice, the institutional legitimacy of the court, its reputation, his reputation as Chief Justice. And, Justice Gorsuch now comes in the court from a very interesting context, given those sorts of concerns. He was nominated by a president who has, exhibited some contempt for the rule of law, criticizing judges when they disagree with him or rule against him. He promised that the judge that he would appoint, would pass certain litmus tests on guns, religious liberty, abortion. We, of course, don't know what conversations happened between President Trump and Judge Gorsuch when he was deciding whether to nominate him. But these raise real questions about whether, Judge Gorsuch is going to simply, represent certain segments of the population as the president said. He promised a justice who would represent evangelicals, or whether he'll do what judges are supposed to do, which is to apply the law, faithfully and apply the text and history of the Constitution, apply the laws as Congress wrote them. And so I think, in his first, sitting this term, and then in the next couple of terms ahead, I think people are going to be watching really closely to see whether he is simply, allied with the president who appointed him, or whether he is doing, what we would hope a justice would do, which is applying the law. And I think that question is really going to determine whether he, is someone for liberals to fear. He says that he's an originalist. That's not a problem from a progressive perspective. The question is whether he applies the text and history of all of the Constitution, or just the parts of it that he likes. There was, I think, looking at his record and listening to what he said at his confirmation hearings, some reason to question whether he's actually an originalist or more of a selective originalist who, privileges the parts of the Constitution, as I said, that he liked, the ones that were part of the document as it was first written, or whether he'll look at all of the text and history and apply the Constitution as it now stands. So, showing the proper respect for the Reconstruction amendments that abolished slavery, that guaranteed to everyone the equal protection of the laws, that provided that there should be no racial discrimination in voting. I think these are the big questions that we're going to see as we move forward. In terms of his relationship with Justice Kennedy, obviously they have a close one. He clerked for the justice, which is kind of a phenomenal thing, right? To see a former clerk sitting beside his former boss on the bench. But Justice Kennedy also had...
Roberts was going to be that way if
he
Roberts
was, right?
hadn't died in time, yeah.
But Justice Kennedy has been there for a long time. He has, he has a very strong sense of what his own jurisprudential views are, and I think he's going to continue to do what he thinks is right, and will consider to be the vote that is most often in play as we move forward.
Great. Joan, you raised this important question that everyone is jumping into, but didn't quite answer it. Is there a scenario where Justice Gorsuch would join with Chief Justice Roberts to put the institutional legitimacy of the court first? And could you imagine supermajorities in a case like the travel ban case, for example, checking the president and showing a bipartisan commitment to the rule of law?
I can, and I'll tell you what I think might happen. I think we're talking about a continuum of watching what he does. I think that he will probably take some safe, smaller steps in the beginning. Justice David Souter famously said it usually takes 5 years to get up to speed there. Now, other justices have felt like they didn't need quite 5 years. But if you look back and think about how Justice Souter himself ruled in some of those early cases, for example, one called Russ versus Sullivan, where he joined with conservatives in an abortion-related dispute, and then turned out to be one of the surer liberals there, I bet we see Justice Gorsuch takes, this is, obviously we're all speculating here where he would go, but I would think in the beginning he will take kind of the safer conservative position. Nothing too daring, nothing too flashy, just because it will be a more comfortable spot for him. It will look like he's delivering more. And as probably many of you in this room know, the process by which Justice Gorsuch was chosen was run by some very serious conservatives who had in their head the mantra, no more suitors. So I think that they are convinced that he will be more with a Justice Alito than a Chief Justice or a Justice Kennedy on
But also no more
things.
Robertses to a certain extent.
But yeah, that's right.
Which is a different problem.
No, that's right. But I think the kind of markers that we've already seen of Justice Gorsuch in his past life, in the kind of the Marshall scholar that he was, the sort of looking toward international themes more than Justices Alito or Thomas, I could see him moving more toward the center. Now, the thing about Justice Kennedy, we identify him so much in terms of what he's done on gay marriage, key vote for it. We identify him with upholding abortion rights. But I think Justice Kennedy still thinks of himself much more as a center-right justice than a center-left justice. So given the correct set of cases, like a Shelby County, he certainly is with the conservatives, and I think Neil Gorsuch would be too on something like that.
Great. Ilya, you wrote, "I'm pleased as punch with the selection of Gorsuch," and have praised him for all sorts of reasons. In what ways?
Did I write that or did I tweet that?
Well, it was
all right.
true. As you wrote it. It was in the Cato. It was an op-ed for Cato, and you said, "As you can see by my statement to CNN."
Okay.
And so it was an extensive. It wasn't just a mere a tweet.
What do you think? Pleased as punch
I'm
sounded a
pleased
little
as
too
punch.
casual?
Although you did. Speaking of Twitter, you said right before that your first choice from the fabulous list of terrific judges. They're all winners. Believe me, you said. Nice. Touch. Believe me, all winners. Solid list. No, really, solid list. You said was probably the judiciary's Twitter laureate, Texas Supreme Court Justice Don Willett, who is indeed great to follow, but Judge Gorsuch was right up there. Justice Scalia was a Hamiltonian. He favored extensive federal power. He wanted to defer to the federal government's power to preempt Oregon's euthanasia laws. Gorsuch is arguably more of a Jeffersonian and more of a libertarian. Do you think that's incredibly insightful statement, which I ventured in the Atlantic, is correct or not? And if it is, how would Justice Scalia be more? How would Justice Gorsuch be more libertarian and Jeffersonian than Justice Scalia?
Gorsuch is younger, and that's not just kind of a banal factual thing, but the debates over jurisprudence and the conservative reaction to the so-called liberal activism of the 60s and 70s that Scalia was involved with is different from the jurisprudential debates that we have now, where we think that, well, maybe just being judicially restrained, the Borkian Scalia school, isn't the way to go. Maybe we need to actually grapple with some of these underlying presumptions. And whereas Scalia had made his peace with the New Deal kind of compromise of amending the Constitution sub rosa, Gorsuch might want to push back on that in some ways when the government is going beyond its structural bounds. And on the Jeffersonian point, probably my favorite quote of his from his 10th Circuit opinions is in a case called United States versus Kruger from just a couple of years ago. It involved a motion to suppress evidence that was collected pursuant to a warrant that was issued in Kansas, and the evidence was collected in Oklahoma. And he wrote in suppressing this evidence, because the warrant was no good, ours is not the government of the Hunger Games with power centralized in one district. Instead, it creates a republic of diffuse and dispersed powers along those lines. And so I think he takes structure very seriously and is going to be willing to push back, as you said, when the national government goes too far.
So, Brianne, once again, libertarian, Jeffersonian dream, progressive nightmare. The Constitutional Accountability Center wrote a very rigorous critique of Justice Gorsuch for being pro-business and spelled out those cases. And Ilya has already raised the possibility that Justice Gorsuch could be more skeptical of the administrative state and overturn the doctrine that had judges defer to reasonable agency interpretations and perhaps be more willing to dismantle the administrative state than Justice Scalia. So spell out that scenario, if you will.
Yeah, it was pretty stunning when his nomination was announced because the business community did not hide their excitement. One of the senior members of the Chamber of Commerce said it was a fantastic nomination. Defense side lawyers were talking about he will return the court to its pro-business leanings. And that's a really significant thing because the Roberts Court has been markedly more pro-business than either of the courts that preceded it. I think we've been at the Constitutional Accountability Center have been tracking the success of the Chamber of Commerce in merits cases at the court. And the Roberts Court has voted for the chamber in roughly 69% of the cases compared to, I think, about 56% of the cases in a stable period of the Rehnquist Court and just 43% of cases in the Berger Court. So it's been, consistently pro-business, making it more difficult for employees and consumers to bring class actions, forcing people to arbitrate instead of go to court. And the business community thinks that Neil Gorsuch is going to continue that trend. And one important way, as you said, Jeff, is by potentially overturning a decades-old precedent called Chevron, which provides that courts should defer to reasonable interpretations of agencies when they're administering ambiguous statutes. And this is a really big deal because Congress has been relying on this and will often delegate authority to administrative agencies, recognizing they're the experts. They can look at changing circumstances and figure out how best to apply and administer the law. Neil Gorsuch, it was funny listening to him at his confirmation hearings. I don't know how many times he said it, but I feel like quite a lot. A good judge respects precedent. A good judge follows precedent. Even as a Court of Appeals judge, he was not shy about telling the Supreme Court and everyone else when he disagreed with their precedent. And so, he wrote a concurrence to his own majority opinion just to go out of the way and say, you know what, I think the Chevron case raises really serious constitutional problems. And that's interesting in large part because it shows a significant way in which he differs from Justice Scalia, and so could really mark a change on the court going forward. There was Justice Scalia, applied Chevron. There was a case from a few years ago called FCC v. City of Arlington, in which Justice Scalia applied the Chevron deference doctrine. Chief Justice Roberts dissented, criticizing the doctrine, saying that it was inconsistent with what the founders would have envisioned, and Scalia just was having none of it. He said that the Chief Justice's approach would have marked, a massive revision in the court's jurisprudence in this area. And so now that we don't have a Justice Scalia anymore, and we have a Justice Gorsuch, and we have other conservatives on the court who've been kind of having their target set on Chevron, I think that's an area that's really important to watch. And as Ilya said, obviously deferring to administrative agencies can result in results that are both liberal and conservative, but there are lots of regulations that protect the environment, that protect consumers, that protect employees, and a lot of these may be more endangered if the court says that it won't defer to agency interpretations.
Let's recall how Chevron originated, and this wasn't just about just real quick.
No, you can weigh in fully, but explain, disaggregate for the audience.
Yeah,
This is kind of complicated, and explain to us why under liberal administrations, deference to administrative agencies like the Environmental Protection Agency or the Federal Communication Agency might lead to liberal results, but it's possible under a Trump administration, refusal to defer to the agency interpretations and saying, no, Congress actually required you to regulate EPA, you, Trump, EPA, are not allowed to deregulate, might lead to progressive results. Help us understand all that.
Yeah, so why this is even an issue in the law and why it's so important is because of basic constitutional separation of powers, right? Congress is the legislative branch, the president and the agencies, the departments are the executive branch, and it's the legislative branch that's supposed to make the law and the executive branch that enforces it. So how is it that so much of our law now are these regulations and even informal guidances that are promulgated by these agencies, by the executive branch? And why should judges defer to that? Why should the checks and balances, the third branch, when it's reviewing what the executive branch is doing, why should it defer to what some people would characterize as lawmaking? Well, because if they didn't, then it would be chaos, and you can't run modern government another way, and all these things. The deference doctrines, the Chevron, and there's other ones. Chevron is about judicial deference to agency interpretations of congressional statutes. If they find something ambiguous and they want to fill in the blanks by passing a regulation, is that interpretation, is that regulation kind of reasonable, or is it arbitrary and capricious? The courts will defer unless it's arbitrary and capricious. There's other kinds of deference that are probably more under the gun now with Gorsuch joining than Chevron about agencies' reinterpretations of its own regulations. There's other technicalities. But the thing is, this really does cut across ideological grounds, not just because of results, but because even when you think of Chevron itself, that was promulgated by conservative justices in the 1980s as a reaction to the liberal judges on the DC circuit thwarting President Reagan's deregulatory agenda. And there's all of these structural cross-currents, both on the left and the right, and more in academia now than what we see on the court, I suppose, that go into this debate. And so it'll be really interesting to see exactly where the pushback is headed, because this is an area that's rife for, that has been engaged in political debate in Congress, in academia, and in the courts the last 5-10 years.
Great. Ladies and gentlemen, administrative law is really wonky, even for law students, but we all have to learn about it now. It's important, and we're seeing the Congress is debating whether to have real deregulation, and we may see it on the courts too. We had a great series of programs.
Make sure to ask Mike Lee about his Article 1 project and why libertarians want Congress to have more power.
I will do that, because and the Article 1 project, which is part of the Federalist Society, which is our great partner in this Madisonian Commission, along with the Progressive American Constitution Society, says, as Ilya suggests, Congress has to assert its power and not allow the executive to seize all of this unregulated power on its own. So Mike Lee is criticizing Congress for being inactive, and this doesn't always, it leads to conservative as well as progressive results. But I want you to dig in a little bit And we had a great series of programs on the administrative state co-sponsored by the Federal Judicial Center a few months ago, and there were some great panels which you can find on YouTube. And so pick up part of the interactive Constitution, learn about the non-delegation doctrine, and then you'll be able to follow these really important debates about the future of regulation. I know you can do it. Joan, this audience is wonderful. They're lifelong learners, and they accept homework from this law professor without too much complaint. This question, more broadly, of whether structural restraints on the president and Congress enforced by an independent judiciary might be embraced by progressives as well as conservatives, was the topic of this phenomenal new commission we've launched, the Madisonian Constitution for All. Can you imagine liberal as well as conservative justices converging around the enforcement of these provisions that would check the power of executive orders in the presidency as well as force Congress to do its job? Or is this an academic pipe dream and will be a lot of 5-4 liberals versus
No,
conservatives?
I mean, think of who we have on this court and their backgrounds. Think of where they came from and their vested interest. Justice Scalia was very much of the executive branch and not of Congress. He considered Congress fairly sloppy in what it did. He was suspicious of how it wrote legislation. In fact, he was the strongest proponent up there of ignoring legislative history, the floor statements, the committee reports. So he had already staked out this kind of pro-executive, anti-congressional view when you talk about the relationship among the branches. Neil Gorsuch spent time in the Justice Department, as did the chief and Samuel Alito and Elena Kagan. And the experience crosses ideological boundaries. The man who really gets Congress is Stephen Breyer, because he worked for Teddy Kennedy, the late Massachusetts Democrat, helping with the deregulation of the airlines, doing the sentencing, new sentencing guidelines. So he really understands how legislation percolates up and that it's a messy process and that sometimes there's going to be enough ambiguity that go ahead and defer to how an agency is going to play it out. So to answer your basic question about the cross currents ideologically, I would say yes, I think liberals and conservatives will both be re-examining some of these questions, and with the huge overlay of Donald Trump. Donald Trump and many of the bold things he's already tried to do. The one that we've talked about already is the travel ban involving countries where there are certain Muslim majorities. But think of all the other things he has promised and things that he has tried to do that will put in the judiciary's hands, for better or for worse, a check here. And I think that even the decisions we already saw relative to the travel ban showed the lower federal courts ready to step up on that. Now, interestingly, the lower federal courts, I think they were also looking at an 8-justice Supreme Court where they knew it was going to be deadlocked. Now they see there will be 5 members who perhaps would be leaning conservative, but I would think that Justices Kennedy and the Chief Justice John Roberts would take very seriously that check on the president under these conditions.
Brianne, now Joan has given us a kind of progressive dream scenario where the liberals and conservatives converge to check both this president and this Congress by enforcing structural limitations. Could you imagine that happening in the travel ban case? And more broadly, you clerked for Justice Breyer. He had such a pragmatic alliance with the chief and with Justice Kennedy and Justice Kagan in some cases. Might Judge Gorsuch be part of that alliance or not?
I think I could definitely imagine the sort of alliance that Joan suggested in the travel ban case. And I think there are arguments that are being made in the lower courts that we're already seeing in lower court opinions about how this sort of targeting of Muslim majority countries against the the background of the president's statements while a candidate that he wanted to ban Muslims from coming into the country, those sort of statements and this sort of action runs up against fundamental principles in our Constitution, that we don't favor or disfavor any particular religion, and we don't discriminate, on the basis of national origin. And I think, particularly given the way that this president has acted thus far, the comments that he's made about the judiciary, I would hope that all of the justices will take very seriously the role of the courts to act as an independent check on illegal action by the executive branch. I mean, that was an important reason why our founders set up the federal courts in the first place, to make sure that individuals had a place to go, a place to seek recourse if the other branches were engaging in illegal activity. And I think you could certainly imagine Justice Breyer, the other justices, working with Justice Gorsuch and trying to seek common ground with him. I think a lot of that will depend on what Justice Gorsuch does and how he views his role. If he takes seriously his role as a justice, as an independent check on the executive branch, as someone who faithfully applies the law, I think Justice Breyer and Justice Kennedy and the Chief Justice, all of them will obviously, try to seek common ground. And, I think the court, we talked about how the Chief Justice takes very seriously, and I think, the court as a whole does the role, and they want to be seen as judges, not as politicians in robes. And, the travel ban will be one important case that, people will consider as they assess whether that's true or not.
Can I add something about Justice Breyer that,
Sure.
Brianne, since you clerked for him, you might be reluctant to say this, but I have seen over the past the year and a half with Justice Scalia's death and the court having to come together with consensus on many, many cases that could have been tossed out if they didn't get consensus. Justice Breyer playing a key role. Justice Breyer was appointed in 1994 by Bill Clinton and is, generally a liberal. But as I say, he comes from the legislative realm where he's sort of willing to kind of work in a different way among his colleagues. And he took a long trip with then Judge Gorsuch overseas. They know each other from some of their travels through judicial conferences. And they were both Marshall scholars, as was Jeff. Yes. So I will add that. But so I could see that some of the personal dynamic coming in there. So I thought I'd just mention that, knowing that you probably wouldn't want to give too many inside clues about what Justice Breyer has been doing behind the scenes in conference.
Well, speaking of the travel ban, I wrote an op-ed about how Gorsuch would be more likely than Merrick Garland to vote against the Trump travel ban, just because of their relationship of deference to government and their records in that respect.
Joan, what was the part of the confirmation hearings that taught you the most? It's sort of conventional wisdom to dismiss it as kabuki theater and say it's pointless. There's a lot going on there. Fascinating statements by the senators and by Judge Gorsuch. What did you learn?
How he wanted to present himself. I've been watching these since, in person since David Souter in 1990. And my first day there, I thought, honey, they shrunk the desk. Because he was not sitting at a long draped table as usual. He was sitting at a smaller one-person desk and almost looked like a bureaucrat, functionary, as he was taking notes. And he kept portraying himself as so modest and judges as so modest. And I actually used that device to find out why he had chosen that. And he specifically said that he did not want to be at the usual draped table. Both Justices Sam Alito and John Roberts, when they were up for their confirmation hearings, were at these beautiful red cloth tables. And Kagan and Sotomayor were at green, black cloth, and Clarence Thomas it happened to be green. He wanted the sort of the atmosphere to look more modest, as he kept using that word, to downplay the role of the judiciary in the face of what Congress could be doing. We all remember that throughout so much of the Q&A, he said, that's something for Congress. Congress still has a role in here. No matter what happened in Citizens United, Congress still has a role. So I was interested in how he wanted to portray himself. But I was also aware that any way that he was going to portray himself, any way that he was going to talk about any answer was designed for one purpose, to get confirmed, to get confirmed. I can't fault him for that because, heck, you've gotten that far. Do you want to really do what Robert Bork did and engage in this intellectual feast, as he said? Or, Justice Souter did tell us much more. And even Justices Alito and the Chief Justice John Roberts told us more. But I think given the way that he was appointed after all those months of Merrick Garland sitting out there, I don't think the Republicans wanted to leave anything to chance here, unfortunately.
A really interesting detail about that table, and that does tell us a lot about him. Brianne, you mentioned cases where both Justice Scalia and you suggested Justice Gorsuch might be unfaithful to original understanding, and the Constitutional Accountability Center filed briefs about that. Any moments in the hearings, and in particular, this may just be a thing of mine, but I'll just say I was not satisfied with his answer about how Brown versus Board of Education is consistent with original understanding. Were you, and if not, tell the audience why not?
What I found particularly interesting was actually what he was willing to say and what he was unwilling to say. I mean, I think the main thing people said coming out of his hearing was, wow, he just didn't say anything. And this has been, a continuing trend. It seems like each confirmation hearing, the justices say, or the nominee says less and less. But actually, he was willing to say some things. He said that he thought Brown v. Board of Education was not only a seminal precedent, he said that he thought it was rightly decided. And I think he is, of course, right about that, and he's right that it's consistent with the original understanding. He probably did not go as much into detail as one would have desired, but he said it was right.
I'm so sorry to stop here. This is a totally academic debate, but it's important to me, so I'm going to ask you because you're the expert on it. So as I asked Justice Scalia this question. I may have told this story on one of these panels. I had this incredible dinner with Justice Scalia, and we both had a little bit to drink, and I finally said, Justice Scalia, I just can't help but ask you this. The leading conservative scholar of the 14th Amendment, Michael McConnell, concedes that Brown was not consistent with original understanding because people stood up in the Congress that passed the 14th Amendment and said, don't worry, this is not going to apply to desegregate schools. It was only in 1875 that Republicans changed their mind and said, maybe it will, but if you're just going to be a strict originalist, then Brown wasn't consistent with that original understanding. Justice Scalia, what do you have to say? He paused for a moment and then threw back his head and said, you know what? No theory is perfect. So that was his. But are you not moved by the difference between the original understanding of the framers in 1866 versus those of later? And is this not a problem for originalists?
No, I mean, I think Judge Gorsuch, got it right when he said that we, don't look into the individual hearts of the people who wrote the law. We look into the law that they wrote. The 14th Amendment, as he said, is a radical promise of equality. It guarantees everyone equal protection under the laws. And when you, look at the debates surrounding the 14th Amendment, they wanted to make sure that, everyone, including, recently freed slaves, got the equal opportunity that they were supposed to get under the law. So I think that there is, a very strong original understanding defense of Brown v. Board of Education. But what I think was particularly interesting about the hearing was he said that was right. He said Virginia v. Loving, which was the Supreme Court case that struck down Virginia's anti-miscegenation law, that was a correctly decided case. And then there were a whole string of cases where he said it's precedent. It's precedent, it's a seminal precedent, perhaps it's an important precedent, but he would not say that it was correctly decided. So that included Griswold, Eisenstadt, Roe v. Wade, Obergefell. So
tell the audience what these cases are.
Yeah, so these are cases that are about the fundamental right to privacy, about the right to contraception. Roe v. Wade, of course, recognizing the fundamental right to choose. Obergefell, the decision from just a couple years ago, recognizing a nationwide right to marriage equality. So decades and decades worth of precedent, and again guaranteeing fundamental rights grounded in liberty and the autonomy of the individual. And he would say they're precedents, which of course no one could disagree with, but he wouldn't say they were right, where he's willing to say these other decisions were right, which I think perhaps tells us something about his views on these very important issues. It was interesting too that there were some amendments he was willing to talk about and others that he wasn't. So when he got asked about the Fourth Amendment, protection against unreasonable searches and seizures, he was able to, and talked quite enthusiastically about what that amendment is about how that amendment, enacted in the late 18th century can help resolve, 21st century problems involving technologies that the framers couldn't have conceived of. But, when asked to talk about the 15th Amendment, which guarantees a right to vote free of racial discrimination, he wouldn't really talk about it. When asked to talk about the Foreign Emoluments Clause, this is the clause that has gotten a lot of attention recently. It was not one that people focused on much before a few months ago, but it's critically important. It's one of the critically important anti-corruption provisions in the Constitution. It provides that federal office holders can't accept any present or gift or emolument of any kind, whatever, from foreign states. And the founders included this provision and a related domestic emoluments clause because they were deeply, deeply worried about corruption. And so he was asked, what do you think the purpose of this clause was? And that should have been an easy question for an originalist. The purpose of this clause was to address concerns about corruption, to address concerns about foreign influence, to ensure that federal office holders are acting in the national interest and not their own personal self-interest. And yet he would say nothing about it. He was even pressed, you were willing to talk about the Fourth Amendment, you're willing to talk about other amendments, and wouldn't talk about what that amendment means. And I think that was really interesting and telling too.
Joan, you wanted to talk about assisted suicide, and you wrote a great piece about his book about assisted suicide.
Yeah,
as
in
well.
fact, I think there's two categories of where we didn't quite get the straight story. One is on a topic like Brianne mentioned, where he probably thought, okay, Donald Trump will be sued, and the foreign emoluments clause will probably come in, that sort of thing. But I felt that he could have told us much more were on questions of due process and privacy. He wrote a 311-page book about how he felt about the right, or actually not the right, of assisted suicide, a very strong volume that came out of his dissertation when he was an Oxford scholar. And in it, he acknowledges that under his theory, the fetus would be considered a person who could not be killed, because he doesn't believe in any taking of an individual life, whether it be in the assisted suicide context or the abortion context. But he did allow in a footnote that Roe v. Wade, said that the fetus wasn't a person, so it wouldn't apply. But he at least voiced in this 2006 book, 2006 was when 2006 book, very, very strong views about the states that have tried to who have in fact accomplished a right to assisted suicide. Now the language isn't quite that. It's like the aid in dying language, which he sort of poo-poos that kind of language in his book. But he didn't want to go there at all because I think he would have been trapped in some ways because he was on record.
Well, he didn't want to discuss anything of substance because of his incentive of just to get confirmed. And so he basically, what he said on that was the book speaks for itself, I think is what he said. Which did the trick. He got confirmed. I mean, we have to.
Well, that's it. And Senator Feinstein, who really cares about that issue, she was one of the people who said, we're just not getting anything here.
But you read the book, Joan, and you wrote a great piece. What are the implications of his views for Roe and assisted suicide? He claimed that although he recognizes a deontological, and I did have to look that up, and that means an argument made without regard to its consequences. It's not a pragmatic argument. It's inherently wrong, says Justice Gorsuch in this book, to take life under any circumstances. What are the implications of that for Roe and assisted suicide? And were you persuaded by his claim that he was speaking as a commentator, by which maybe did he mean a moral commentator rather than a constitutional commentator, and that the court had ruled definitively that fetuses do not have a constitutional right to life?
Well, the same Supreme Court he's now on could reverse that. And if you take his argument to its logical conclusion, the conclusion that Justice Scalia wanted to take it to, Justice Scalia was ready to overrule Roe, was ready to overrule Casey in 1992. If he took his argument, whether you want to call it moral, social, academic, because he did talk about it in the academic vein too, as a commentator, if you took it to its logical conclusion, he would vote to reverse Roe v. Wade because he would consider it the killing of an individual life that should be spared. Now he did, it was interesting to use the word commentator. Again, it goes to what I was saying, there was not a single answer he gave, I am convinced, that had not been rehearsed many, many times. And again, preparation is good. We all, Jeffrey wants you to believe in homework, and I believe in preparation. So it was good that he was prepared.
That's why we spent all those hours in the green room.
But so he was ready to describe that book in a certain way. He knew he was going to get questions on that, and what he wanted to do was to say, I'm a commentator. I wasn't talking as a judge. But that was something he was really committed to. As we all know, you don't write a book unless you're really committed to the topic.
Okay, we're going to start with some of our great audience questions, and the first one's really important. Senator Chuck Grassley suggested recently that there may be another SCOTUS retirement this summer. The question is, any truth to it? Ilya, if you know anything that the rest of us don't, share it. But I'll just follow up on that to say, if there is another retirement, and let's imagine it's Justice Kennedy, has all of our discussion so far gone out the window? And is all the incentive to compromise gone? And then is it just a hard, whatever it is, 6-3 conservative court, if I'm getting it right, where Justice Gorsuch has no incentive to compromise?
Well, I don't have any inside information, and Grassley is prone to talking off the top of his head. I don't know if unless he talked to Kennedy himself or his wife, then you have to discount the information because, Joan and I were talking beforehand. I'm not sure Kennedy yet knows when and if he wants to retire. I mean, he's in a pretty good spot, right? I mean, as long as his health allows him, he's got a pretty cushy job. He's got the best lawyers in America writing opinions and doing research for him. He gets his summers off so he can go tour Europe and lecture. You only have to be in Washington to hear argument a week and a half out of the month. It's not the most taxing of jobs. And this is Kennedy, all the power. The second biggest judicial winner after Gorsuch of the election was Kennedy because he gets to remain the swing vote as long as he wants. So, who knows? If he is replaced by a Trump nominee, it'll probably be of the kind that's on the list that Trump put out, not necessarily on the list, but of that ilk. I don't think Trump has no incentive to do something crazy like appoint Rudy Giuliani or his own personal New Jersey casino lawyer or Judge Judy or anything like that. I think it'll still be a kind of a Federalist Society type that's been vetted and like that. And so what would that do with the court? Well, it would change a 4-1-4 court to a 5-4 court.
5-4. Yes, obviously my math was bad. Imagine that Kennedy retires, so Kennedy replaced by a reliable conservative of 5-4 court. Let's imagine, Brianne, that it's Justice Ginsburg or Justice Breyer or one of the liberal justices who retires, and then then it would be a 6-3 court or a 5.5 to 3.5 with Justice Kennedy there. Then does the incentives of compromise, the incentives of the chief to make the court appear to be something more than politicians in robes, does that all disappear, or does he still? I think he believes that seriously and earnestly in good faith. Might he still try to maintain bipartisan majorities even in that scenario?
I mean, I do think the chief believes very strongly and cares very much about the institutional legitimacy of the court. He doesn't want them to be seen as politicians. But, with that composition of the court, the fact is, despite all that, the Chief Justice is very conservative, and his votes in many, many areas reflect his ideological views. And I think, with that kind of court, one would have to worry about the future of, a right to abortion, the future of marriage equality, the future of, access to the courts, a whole lot of different issues that, at least now, there's, some equipoise because Justice Kennedy will at least sometimes side with the court's more liberal justices. We're living in a very different world then.
Joan, here you wrote this great book on Justice Scalia, which I recommend to our friends in the audience. It says, Justice Scalia was known as an originalist. What would that be like? Of course, it goes in that direction now. Please be as specific as possible. Thank you. So I think we want specific examples of how an originalist Justice Gorsuch would rule, and I'll ask the obvious follow-up. Are there any areas in which the originalist Gorsuch would rule differently than the originalist Scalia?
Well, the one area where Justice Scalia broke from his conservative brethren to side with liberals based on his originalist theory was the right to jury trials. And so he became much more lenient on criminals who saying that you can't have judges just decide aggravating factors that would up the sentences for defendants. That was a big, strong area of his where he might differ from Justice Gorsuch if he isn't the fullest originalist. And let me just say about the word originalism. When I was doing the book on Scalia, Sam Alito said to me, well, I think I'm an originalist and I don't rule the way he does. There are different brands of it. Basically,
what are they? What are the different brands?
When you think, I'm just going to say the fundamental one is that a jurist is going to look to the understanding of the Constitution as it was written. What was the understanding?
It's actually not that, Joan. See, this is what's funny about these questions about originalism that have gone to non-originalists.
Well, wait a minute, let me finish this because it's not. There isn't a fixed meaning, as Sam Alito even demonstrated. He was looking at things, believing that he was taking an originalist view in a way that Scalia was violating. So, what we know of now Justice Gorsuch is that he has identified himself as an originalist in the mode of Scalia. And I don't know if we're actually going to see that. I'm just saying that enough of them have variations. And if you want to talk the true originalist, I mean, some people would think it would be Clarence Thomas. Because when you take an issue like Brown v. Board, if you take an issue, what he has said is that he would not let precedent stand in his way. Justice Scalia at least would say, there are certain precedents I'm not going to touch. I wouldn't have been part of the original majority, and Brown would probably be one of those, would not necessarily be part of the original majority, but I'm not going to sit there and overrule it now.
Yes, I think.
Can I clarify this?
You can indeed. I think you reported in your book that great quote from Justice Scalia. The difference between me and Thomas, said Scalia, is Thomas, would overturn any precedent he thinks is inconsistent with original understanding. I wouldn't do that, said Justice Scalia, because I'm not a nut.
No, and that was what, and he said that about textualism too. I'm a textualist, I'm not a nut. So there's not, and I think that probably the author of the question probably appreciated that when saying, specifically where would they go? And right now, there isn't just one theory, just like it's not just one liberal versus conservative. Talk about the Cato Libertarian view of originalism, of the brand you were going to say, might differ from these, but I just would never say that it was a fixed definition.
So disaggregate, explain the different definitions, and then tell us how the originalist Gorsuch would be different.
I wasn't trying to push libertarian originalism, although my brand of originalism does allow me to file briefs with the Constitutional Accountability Center in Obergefell on gay marriage and certain other things, because you don't look to the original understanding or expectation of what the legislatures or the people expected the law to do, but the original public meaning of the words, of the text. And that's where there's a slight wrinkle. We've already thrown off original intent originalism, because it's not, what James Madison thought about video games is how you apply that. It's not that, or whether Jefferson would have attached GPS devices onto his slaves, or that's not it. That's Dianne Feinstein, what I call Prague-splaining, of explaining what originalism means when you're not an originalist. It's the public meaning of the words of the text. It's textualism for the Constitution, if you will. And you can absolutely have debates about what that means, how to apply that in the modern day. And then on top of that, you have the debate over stare decisis, which is sort of what you got to talking into towards the end there, Joan, about how much to maintain reliance interests of precedents old, it's been relied upon, even if you disagree with it. At what point do you overturn that? And certainly there's a debate on that, which is separate from how you apply the original public meaning in the first place.
And can I just add, to the list of justices who've identified themselves as originalists, there's also Justice Ginsburg. She's called herself an originalist, and I think that's that's a really important point, because the fact is we can disagree about what the original meaning is with respect to any given question. But I think, and this is one of the great legacies of Justice Scalia, is that basically all judges now look to the text and the history of the Constitution, and again they may disagree somewhat about how to go about doing that. But that's where everyone starts, and that's why there's this tendency to associate originalism with the right. But the fact is, if you look at the text and history of the Constitution, if you look in particular at the text and history of the entire Constitution, what you'll see, and this is what my organization does, we are dedicated to the progressive promise of the Constitution's text and history. We think that it leads in many, many cases to progressive results, and that's why someone like Ruth Bader Ginsburg can proclaim herself an originalist. And that's why, I don't always agree with where Justice Scalia, where originalism always led him. I think he often led him, to the wrong places, but it doesn't mean he was asking the wrong questions. A
superb example of that was the Heller Guns case.
Yeah.
In the Second Amendment case, where Justice Scalia was able to get a majority to say that the right to bear arms in the Constitution covers an individual right for having a firearm in your home for safety, Justice Stevens countered him royally with his own originalist point of view. Unfortunately, he was on the losing side for him. But again, that was another one where you're an originalist. No, I'm an originalist,
So just to sum up this really important and fascinating thread, what you've heard from all of our panelists was Justice Scalia had a huge influence in changing the terms of legal debate. As Elena Kagan said when she was dean of Harvard Law School, paying tribute to Justice Scalia, thanks to you, Justice Scalia, she said, we are all originalists now, progressives as well as libertarians and conservatives. But there are different forms of originalism. So Ilya told you about two of them. One is, what did James Madison think when he was writing the Constitution in Independence Hall? That's what he called original expectations originalism. He says that conservative and libertarian originalists don't care what James Madison thought. They care about the original public meaning of the Constitution when it was ratified. So that's why it's relevant to read the Federalist Papers, because the people read the Federalist Papers in trying to decide what the Constitution meant. And that's why the first public printing of the Constitution, which you can see over in the Bill of Rights gallery here, is, according to some scholars, all of them affiliated with the National Constitution Center, even more constitutionally significant than the one in the archives, because it's the public one that created the public meaning that actually gave the thing life. And then Brianne says even people like Justice Ginsburg think, yes, you care about text and history, but you choose a level of abstraction that captures the public meaning in a more expansive way. So that's why that debate I was having with Brianne, the original expectations, what did the framers think about the 14th Amendment? They thought it would apply to civil rights, not political and social rights, and schools weren't a civil right. But the broader conception, no, they wanted to stop legislation that degraded African Americans and affixed a badge of stigma to them. And that is a much more expansive reading. So learn about the methodologies of interpretation and realize that you can care about text and history, but still reach different results. Just time for one or two more questions following up on all this, and this is obviously for you, Brianne. A criticism of Justice Gorsuch is that he's a selective originalist. What is an example where Justice Gorsuch ruled based on an ideology instead of based on originalism?
Well, I mean, I think when you look at his record, what you see is that he will, often wax poetic about the original founders, about the original text of the Constitution as enacted in 1789, but he is much less solicitous, pays much less attention to everything that followed that. So all of the amendments like the 13th Amendment, the 14th Amendment, and the 15th Amendment that radically changed our Constitution, that were transformative, recognizing, as he said at his hearing, a radical right to equality and giving Congress significant power to enforce those rights. So, you look at, for example, his decision in the Hobby Lobby cases, which we've talked a little bit about, privileging, his conception of religious liberty over the federal rights of women who, are arguing that they are entitled to their contraception. That was a case under a federal statute, but indicates the same sort of thing where his, approach to the law leads him to sometimes, it seems, privilege kind of the parts of it that he likes better and not weighing as much as he should the federal rights of individuals.
We have two questions on cameras in the courtroom, so I'll just ask you, Joan. They're basically, how do you think he'll come down? Chief Justice Roberts recently said it's not the job of the court to educate people. It'd be better to have cameras, but it's not to educate people, but our job is not educational.
That was such an interesting comment.
Wasn't it?
I think we both seized on that. He was giving a speech recently at Rensselaer. It was a great Q&A. I recommend it. It's online. You can get it on YouTube. And he was asked about the idea that if you had cameras in the courtroom, people would understand the process more. He earlier had said that he was worried about snippets being taken out of context and all that. We can write snippets out of context if we want, but he challenged the notion that the court should be in a position of educating people, telling them what the process of deciding cases is all about. He said the decisions are too important for our goal to be watered down in any way. Our goal is we're going to try to decide a case. We're going to hear a case. I don't want any examples I give from the bench when I'm talking to a lawyer at the lectern would I have to modify those just because now we'll have cameras? And I thought there was a new kind of answer, tied to rejection of the educational function there. But David Souter, whose name has come up a couple times here, used to say, "Over my dead body," and I think that we're going to have variations of that from all of these justices. Over their dead body, will they have cameras?
Wow.
Yeah.
All right. We're out of time, and we need to enforce it. So just brief closing statements, as economical as possible. How Justice Scalia, we've agreed, was one of the most influential justices of his time in changing the terms of constitutional debate. In 25 years, how influential do you think Justice Gorsuch will be? Ilya?
Very much so, because he shares that commitment, that constitutional structural commitment, as I've mentioned, and writes clearly and without the acerbic flourishes. I think Yeah, he has the potential to be a great and to actually be more influential than Scalia on his colleagues.
Brianne.
I mean, I think it's certainly right that he has the potential to be a hugely influential justice, in part because, as we've seen from his record as a Court of Appeals judge, he's not at all shy about his views, and it's not difficult to imagine that he won't be even more so as a justice. You know, how influential he ends up being, I think, may well depend a lot on kind of what happens over the next few years and what the shape of the court as a whole ends up being.
Joan, last word to you.
Yeah, the two youngest are Elena Kagan, who I believe will be very influential in her time on the left. And I think given his age, that he's only 49, until we see who might come next, he's going to be the leader of the right wing.
Please join me in thanking our superb panel.
Thank you. Thank you. It was a lot of fun.
Thanks, everyone. See you at Member Appreciation Day.